Important judgment by the High Court of Calcutta. This judgment has significant implications for trademark administration in India. So today we are going to examine three appeals which collectively challenge the authority of associate managers of trademark to pass quasi-judicial orders. So now we'll understand what were the facts of this case. The first two appeals were filed by a company called Visa International against the orders dated September 16 passed by an associate manager. The order pertained to oppositions which were filed against trademark application number something in class 6 and 35. The third appeal was lodged by another company which was Garden Silk Mills Private Limited. It was also challenging an order dated October 6, 2023, which was passed by another associate manager of trademarks. This order concerned an opposition to application number something for registration of a mark called Haldnum Greens in class 35. The applicant's primary contention was that these associate managers they lacked the legal authority and competence to pass such orders. So the issue is that these associate managers, do they have any legal authority? Do they have any competence to pass such impugned orders? So the appellants presented evidence showing that the appointment of these officers as hearing officers was on contractual basis, and it had expired in March 31, 2023. Yet they passed orders on September in September. Furthermore, they argued that on June 9 there is an order which did not assign powers to associate managers for conducting hearings and adjudicating matters. The respondents countered by asserting that hearing officers were appointed through a proper process, including public notices and walk-in interviews. They provided office orders detailing the delegation of functions to contractual manpower and the appointment of associate managers. They also argued that the appellant's participation in the proceedings amounted to acquiescence. The court was presented with various documents, including the appointment orders, organizational structures, and the recruitment rules of trademark registry. We will move on to this rules. The court also set some points for these rules. First, we'll understand what was the central issue before the court. The key question was that whether these associate managers of trademark are empowered, do they have any competence to pass a quasi-judicial orders under the Trademark Act. Moving on to the court's decision and reasoning, the Honorable High Court of Calcutta made several crucial observations in this. First was, under Section 3 of Trademark Act, it is said that the Controller General of Patents, Design and Trademarks is the Registrar of Trademarks. It is a straight-up line, which is written in Section 3. The point number 2 was, other officers appointed by the central government should only exercise the registrar's functions if authorized by registrar. So the other officers which are appointed by central government will exercise the functions of registrar if they're authorized by registrar. The power which is vested in the registrar is quasi-judicial in nature, as it is established in the case of Intellectual Property Attorney Association versus Union of India. But what about the term other officers? Other officers which are appointed by central government. The term other officers in Section 3 subsection 2 implies that there should be a cadre of officers. Point number 5 was, while the central government can appoint officers to perform the registrar's functions, these are to be performed under the registrar's superintendence and directions. Now, can any quasi-judicial function must be performed independently? Right. The point is that the quasi-judicial functions must be performed independently. They cannot be subject to anyone's superintendence or directions, including the registrar. So now it means that Section 3.2 is intended to empower the delegation of administrative power and not quasi-judicial power. Section 3 subsection 2 is the intention is that it empowers the officers the administrative power and not the quasi-judicial power. The court found that the associate manager's engagement it had expired on May 31 and March 31st. Yet they passed orders in October and September. The respondents failed to produce any order which was showing the extendment of the engagement of these associate managers. Moreover, the court noted the recruitment rules. They do not include any post of associate managers. Based on these findings, the court concluded that associate managers, which are appointed in Section 3 subsection 2, are not empowered to pass any quasi-judicial orders. Consequently, the court it set aside and quashed the impugn orders which were passed by these associate managers. The court remanded back the matters to the Registrar of Trademarks and to be decided afresh by a competent officer, that means registrar, within 6 months after giving all the parties or the ultimatum, that means opportunity of being heard, right? The court emphasized that its decision was based solely on the issue of associate manager's authority to pass quasi-judicial orders, not on the merits of the case. So the issue is only the competence, not the merit of the opposition case. It clarified that registrar's power under the Trademark Act is quasi-judicial, while delegation of Section 3 subsection 2 is administrative in nature. Addressing the respondent's argument about the maintainability of appeal under Section 91, the court held that appeal was indeed maintainable. It was maintainable, right? As the issue of competence goes to the root of matter. Now we will discuss about the pari materia cases which were referred by the court in this case. First case was JK Medical System Private Limited versus UOI, Union of India. This case interpreted Section 3 and it stated that this section does not impose any restrictions on the central government's power to appoint and authorize officers of designation to undertake quasi-judicial functions. The second case was Intellectual Property Attorneys Association versus Union of India. This judgment established that powers vested in the registrars of trademark under the Trademark Act is quasi-judicial in nature. Right? Simple. The third was the Registrar of Trademark versus Kumar Ranjan Sen. This case discussed the administrative superintendence and direction of the registrar over the officers exercising the powers. That means that the registrar have superintendence over the other officers. Right. The fourth case was M Money versus Sangeeta Theatre and others. The judgment established that if an authority has power under the law, merely not referring to the source of power or referring to wrong provision, it does not vitiate the exercise of power. Simple it is. This landmark judgment by Calcutta High Court offers significant practical value for the legal professionals in the field of intellectual property, particularly in trademark law, as it provides a new avenue for challenging orders based on the competence of the officer. So it means that if at the last it is written this order is passed by associate manager, that means it can be challenged in the court. This ruling may strengthen the strategies, the opposition, the appeal by introducing an additional ground for challenging adverse orders. So this was a very important case. The link for this case and the newsletter is provided at the last of this video. That means it must be coming around here, and also it is mentioned in the description box. So that was my time here, and I will see you in another judgment. Thank you.